What is the relationship between the plaintiff and the defendant?
Plaintiff is the mother-in-law, my lords.
A plaintiff is a
Mother-in-law
mother-in-law.
of the defendant number one.
Defendant number one is the daughter-in-law.
Daughter-in-law.
On there was a interim order of the status quo. She trespassed. First respondent trespassed into the property. Before housewarming ceremony, sir, she suddenly they entered into the second floor of the house and squat over there.
The defendant number one, that is the respondent here in my lords, is the daughter-in-law of the house, and the suit shall property is a matrimonial home. The Honorable Supreme Court of the year 2021, she can claim a right to reside as per section 17 of the Protection of Women from Domestic Violence.
The appellant is not the age about 84 years. Not the suit is for not the mandatory injunction to quit and deliver the vacant position of the Schedule B property. Against the respondent number 1 and 2, who are the husband and wife, or wife and husband. The suit schedule property is the self-acquired property of the plaintiff, who inherited the property from her mother.
Now, what is the relationship between the plaintiff and the defendant?
Relationship is the plaintiff is the mother of respondent number 2.
Plaintiff is a mother.
Mother of
Defendant
respondent
is?
First respondent is the wife of respondent number 2.
Plaintiff is the mother-in-law, my lords.
A plaintiff is a
Mother-in-law
mother-in-law.
of the defendant number one.
Defendant number one is the daughter-in-law.
Daughter-in-law.
Yeah. Yes.
Not,
What is the application that you have filed?
the application they had filed before I could come. This petition is not the pending since 2018. OS is filed on 17/11/2018. On 29/5/2024 itself, the matter was posted for the final argument.
What is the date?
29/5/2024.
Hmm.
Matter was posted for final arguments, after the evidence, and the application was filed on application was filed on 3/7/2024. Before I could say on there was a interim order of the status quo. That is on. The interim order of status quo was the order by the trial court earlier to 2019. I'll give the
What
date.
is the interim order?
Interim order maintain status quo between the parties.
Hmm.
Such being the fact, on 3/7/2024,
Yes.
the respondent number 1 filed the application seeking to provide access to the common areas.
Access to the common.
Access to the common areas. We have filed an objection. Suit is for the 2018. Till 2018 to 24, there was no the impediment for her to this thing and all, using the things and only to the drag on the matter and to harass this the appellant herein.
Please come to the application.
Before I come, I will take my lords to the one moment. I will take this is the self-acquired property of the plaintiff. I will show the sale deed for a moment.
No, before that.
I will come, I will come, that. The page number 55 is the sale deed. This is dated 30/5/1962. The plaintiff's, the appellant's mother purchased this property in the year 1962. That page number 55. 30/5/1962. She purchased. Plaintiff's mother purchased. Plaintiff's mother died in the year 1988.
Yes.
Subsequently, after the death, she inherited this property.
Yes.
My why I am bringing to the knowledge of this honorable court. Either the respondent number 1 or the respondent number 2 has no right over the self-acquired property of the plaintiff.
It will be decided.
That I will come to that.
Yes.
Even in this matter, the IA also
Please come to the IA. What is that they have filed? We will see that.
Yes,
IA.
application is page number 25. Page number.
What is the suit schedule?
Page number
property?
50.
What
Food
is
schedule
this?
property is not a three-floor building, not in one of them, not of the second floor. She not trespassed. First respondent trespassed into the property and not is sitting over the property.
So she's staying in the first floor,
Second floor.
second floor.
Second
Where is the plaintiff staying?
Not
Plaintiff.
plaintiff is not, it is social property belongs to the plaintiff, not due to harassment.
Belongs to
Yes.
him where? In
Yes.
which floor she is residing?
Not I will come before I could come to those things.
Make a submission.
one
Plaintiff
moment,
is
one
not
minute.
residing in the social property.
Yes, I do agree, my lords, because due to harassment caused by the my lords, the respondent number one, my lords, he could not able to stay there. My lords, now he is staying with my lords, her son, doctor one, my lords, the Chandramouli. My lords, he is there. But the fact is this, my lords, in the year 2000,
Yes, sir.
my lords, the impugned order is, my lords, the
For the impugned order,
application,
please
my
come
lords,
to page number 50.
50, my lords.
Yes.
Page number 50, my lords. 50 is the, my lords, the application, what they have
We'll
filed.
look at it. What is that
Yes.
she's asked?
Not for the reason shown to in the accompanying affidavit, defendant number one prays that honorable court may be pleased to direct the plaintiff to allow her access to the common areas in the suit schedule property by opening the locks of the common areas, common utilities as listed below in the interest of justice and equity. Not she has mentioned not there are four not the roof, terrace building stated so and so, utility areas, basement, some so and so. Not we have immediately we have filed the objection. Not this application
There
is
is no, there is just, this is the petition. What is the very, there is no affidavit to this?
There
Yes,
is
ma'am.
affidavit. They have not filed. I too have not received a copy. This is the actual application filed before the Honorable
Okay.
Trial Court, my lords. Is accompanied by affidavit.
No, this order which is referred to at para number 5 is not questioned by him.
My lords, it's
No, at
only
para
for-
number 5, what you say is, this court, after hearing both sides, is pleased to allow the application by the order dated 3/8/2014, directing the plaintiff to allow access to common areas, roof, terrace of the building situated in the fourth floor, utility area, sump area, and common toilet in the basement by opening the
This
lock.
That's not
this is-
complete. I think this is the contempt
Not
application.
this is the petition, what is against which what we have
They have not complied with the order till date, my lords.
No, that order is not questioned.
challenge.
That is dated 3/8/2014.
3/8,
It's the impugned order, my lords.
impugned
It
order,
is
which
the
is
impugned
challenged in
order.
this petition.
You have questioned the 3/8/2014 order in 2024.
No, my lords.
Oh, my lords.
3/8/2024 itself, my lords, she has filed this application.
No, it is wrongly, instead of saying to 3/8/2024,
My lord,
it is typed as 3/8/2014.
no,
or what?
IA was filed on
That's,
3/7/2024.
Please give it to her.
My-
Please tell the court what it is.
My lords, 17/11/2018 is the my lords, they have filed the OS. 6/1/2019 is the my lords, the order of status quo by the my lords, the both the parties. My lords, in the year 2023, my lords, we have approached my lords, this honorable court, wherein my lords, this honorable court directed to my lords, the speed up the proceeding and my lords, the finish it up within 6 months. Not in the year 2023.
No, she is in occupation of the building.
Yes,
You are
ma'am.
not occupying.
Yes,
You are not
yes,
there.
yes,
You are
ma'am.
not using it.
Yes.
So if she uses the common area,
Lords,
what is your
Lord, there was an
difficulty?
interim order earlier on 6/1/2019 till Lords, from that day to up to Lord 2024, there was no impediment for her to Lord the all these things. Now only in the fag end of the stage, Lord. Now the
Let's think that it is at the fag end of the stage. What is the difficulty to the mother?
difficulty is this, Lord.
Is it that she wants to harass her in that way?
No. Difficulty is this, Lords. I may take Lords to the page number 86, Lords, for a moment. What Lord they are doing in the Lord of the suit schedule property. Lord, the son of the Lord of the respondent number one, removing the things, Lord, and Lord of the damaged the property, Lord, glass panes and Lord of the doors and all, Lord, I have produced all those, including CCTV cameras, Lord, his photo could be seen from that. And Lord, if Lordship opened those things, Lord, then Lord, she will remove.
Only these people, everybody is having an access, other people.
No, Lord, first of all, Lord, she is a trespasser. Lord, this is self-acquired property of mother-in-law. Neither Lord the son nor Lord his wife has Lord the right to Lord over the property. Lord, this property is Lord in between dispute is in between the Lord of the respondent number 1 and 2 is Lord since from December 2007. December 2007, Lord, she left the Lord the company of Lord the respondent number 2 and Lord she residing elsewhere. And Lord, this property is not constructed in the year 2014. Lord, 2014, Lord, she obtained the plan. 2015, she started construction. She Lord, completed the construction, Lord, in the year 2018. Lord, before housewarming ceremony, sir, Lord, she suddenly, Lord, they entered into the Lord, the second floor of the house and squat over there. And subsequently, Lord, she filed Lord, the suit seeking Lord, the mandatory injunction to Lord, the
No,
quit and
let's
vacate.
accept all your contentions that the property belongs to you. It's a self-acquired property.
Yes,
Defendant has no right to
Yes.
enter into the property.
yes, Lord.
You have filed a suit seeking recovery of
Yes,
your possession. Now, till pending, when the suit is pending,
Lord, interim order was there to maintain status quo.
status quo is what?
Status quo, Lord. Then again, Lord, considering this application in the fag end of the stage, Lord, in the Lord, the final argument, in 1 or 2 days, Lord, the argument will be over. Lord, at this stage, Lord, considering and Lord, asking him to Lord, the remove the locks and all, Lord, the sump locks and all. Lord, so this at this stage, Lord, if Lord, 2 days, Lord, the argument is finished, Lord, everything will be finished. At this stage, Lord, the order, passing the order to Lord, the provide them access. Lord, if the access is
Please come to the impugned order.
Lord, interim order. Interim order is page number, Lord, the 14, Lord. Relevant is Lord, the page number 20, Lord.
Yes.
Lord, after this, Lord, allowing this application, she filed not 2 applications. One is contempt and one other is not permitted to break open the locks and all. Not subsequent of not this order. Not the impugned order is not the only page number, not the para number 12, not page number 20. Not wherein not the trial court, not the may I read not the trial court mentioned.
I've read it.
Yes, Lord. This is not the when the matter is not the in the fag end of the stage and not the allowing this application. Not the since 2018 to not 24 there was no impediment for not for anything for her. And only Lord of the in the year 2024 filing this application and Lord of the allowing this application and Lord of the and based on that Lord she has filed Lord 2 applications. One is contempt and one is not. Lord, this is the situation. Lord, my submission to my Lord is Lord, there was a Lord the interim order of status quo since Lord 2019. And moreover, Lord, this honorable court in MFA, Lord, they directed the Lord of the trial court to Lord the pass the Lord of this order within Lord of the 6 months. Such being the fact, Lord, this taking Lord of this application and Lord of the passing this order and Lord of the without Lord seeing the earlier order that Lord of the order of status quo and not permitting her permitting the Lord of the respondent number 1 to use the Lord of the that is only Lord in the ground floor toilet and it is meant for Lord of the plaintiff's use, not for Lord. She is only Lord of the second floor, even though she is a trespasser, not a Lord of the tenant, not a Lord of the leaseholder. Nothing is there. Even Lord, if she claims that Lord is a shared household, Lord, she can't be claimed as a shared household because Lord, this property is Lord. She left the company of Lord the second respondent in the year 2007. This property is constructed in the year, started constructed in the year 2014, completed in the year 2018. Lord, April 2018, Lord, she trespassed into the property. And even thereafter, Lord, filed the suit. And Lord, after filing the suit till 2024, there was no impediment. And Lord, the filing of this application, Lord, the allowing Lord at this stage. And Lord, the which Lord, that not only Lord, I have produced the photographs, Lord, showing that Lord, how the son of Lord, the respondent number 1 damaged the Lord door and Lord, the window panes. And Lord, the taking away the things from that Lord, the building and all. It could be seen from the not the photographs of the CCTV. Such being the not the case, not if allowed her to not use the not the common areas, not it will cause not the irreparable not the hardship to the not the appellant herein, because not the if my lords I opened the not the sump and all, she may pollute the water and all, and not the that ground floor not the toilets are situated. Not she is residing in not the second floor. I don't know not what purpose not she needs those things, because not it is my property, not it is not constructed for my purpose, and not even terrace portion also not for what purpose not I don't want to shame not the he is doing not the parties and all, because of that not she wanted not that property in the terrace portion.
Yes.
My lords, the defendant number one, that is the respondent here in my lords, is the daughter-in-law of the house, and the suit shall property is a matrimonial home. And hence, she has claimed in a written statement, the suit is for mandatory injunction filed by the plaintiff seeking for eviction of the defendant number one. The defendant number one has taken a contention that since it is a matrimonial home and a shared household, and as per the division bench judgment of the Honorable Supreme Court of the year 2021, she can claim a right to reside as per Section 17 of the Protection of Women from Domestic Violence Act. The Honorable Supreme Court says, only after leading evidence and only on proof that there is domestic violence and domestic relationship, and it is proved that a shared household, she has a right to reside, and that right has to be decided by the Honorable Civil Court. But meanwhile,
No, right from 2018, you're not using that common areas. So why did you not come up with an application earlier?
Since 2018, they admit I am in possession of the suit shall property or the written statement shall property. My lords, there are various complaints filed which is marked even before the Honorable Trial Court where they have disrupted the electricity, water connection, and I had to live in dark also, and I've approached the BESCOM authorities seeking that please restore the electricity connection because I'm not able to lead day-to-day life. There has been water disruption, and I have gone out from second floor and to fetch even basic for cooking also and drinking also, water purposes also. I had to go out and get the water, my lords. But since now I'm not able to do that because of my health issues, as my with my proceeding age also, I'm in my 40s now, and I'm not able to do that or undergo such sort of effort to get water
Where
or
did
the
you say
basic
all that?
necessity.
Where did you say all that? That what was the reason for moving an application in 2024, when you're staying in the house from the last 6 years?
Well, it's already, those complaints have already been marked.
For this application, there should be a reason when you're moving it in 2024 in a pending suit, being a defendant in the suit. You should say why it is.
I have stated that there has been disruptions, and hence to
To
accept
have
for
the
it-
application, where did
for
you say read it?
it's not there in my file also, my lords.
What have you passed on?
My lords, that was the contempt application because this order was passed on 3/8/2024, directing the plaintiff number one to open the locks within 3 days, which they have not complied with, and hence I was constrained to file a contempt application. Since now there is no water, I mean the water is decreasing day by day. I mean the flow of the water in the
So
kitchen.
it's not you alone staying. There are 3 floors. You stay in one
There's
floor.
no one else staying in the whole building except me and my minor son. My lords. There's no one else in the building.
No, there no
No other occupants.
ground floor and first floor or
Entire thing
vac-
is vacant.
It's
Entire
not
thing.
given. It is not rented out.
I am staying and maintaining the entire property as cleaning and repairs and everything. That is the reason, my lords, I
Is
sought
it
for
correct that
permission.
first the ground floor and the
My lords,
other floor is not occupied
Lords,
by
I am
anybody?
having photographs. Lords, nobody can stay there. Lords, such a Lord, the horrible lady she. Lord, she is aged about 84 years, appellant. And Lord, the after Lord she filed Lord in the year 2007, 498 against all the family members. Lord, all the family members also Lord left this person also Lord, the respondent number 2. He is residing elsewhere. And Lord, because Lord, the 498 days she has filed, Lord, in 498 she herself stated that Lord, since from 2007 up to 2018, Lord, she was in different address. I have produced all those documents before this one. Lord, this Lord, aged about 84 years, this lady. Lord, Lord, if she go near that, Lord, if she push it, Lord, she will fall down. That is the position of her.
Please come.
My lords, my right to possession includes enjoying of whether it is a rightful possession or wrongful
So
possession.
there is
Is
no,
yet to be
no,
decided.
no, there is not, no argument on that is required. It is settled that you have to enjoy it. The only query of the court is, why did you not do it from 18 to 24? That's the only query of the.
My lords, I went to the extent of going out and getting water. I mean, that is the trouble I've been through. But finally, I'm not able to do it due to my health reasons at this stage. And common
Agreed with the
amenities
order
becomes a
passed.
necessity, my lords, to any survival.
The
My lords.
orders passed in. I number 7 and 8, invoice number 8.
Only 7 Lords I have challenged. Only 7 I have challenged.
Only
not-
7 you're
Only
challenging.
7. It was a common.
8 is?
past.
8 is not
To
putting
put
the
up
CCTV camera.
Cameras. Agreed with the orders passed in I number 7, dated 3rd August 2024, and orders number 8286 of 2018. The plaintiff is before this court. The parties are the plaintiff is the mother-in-law, the defendant, or the son and the daughter-in-law.
Defendant number 2 is the son, defendant number 1 is the daughter-in-law.
Defendant number 1 is the daughter-in-law, and defendant number 1 is the son.
Husband of
Defendant number 1 is the daughter-in-law.
Defendant number 1 is the daughter-in-law, 2 is the son.
her husband, my lord. Second, first respondent,
So
sir.
I'm referring to the relief that is sought in the suit is to grant mandatory injunction, directing the defendant to quit, vacate,
My
and
lord.
hand over the vacant portion of the Schedule B property to the plaintiff. The suit is filed in the year 2018.
If I may make a submission, my lords. Now at this stage, I filed an application to break open the locks, especially of the roof, because the water in the kitchen has decreased substantially, the water flow, to get the repair done, my lords. All the water ducts are either there in the utility area in the basement or on the terrace, for which I have no access. If the water stops tomorrow, my lords, I have absolutely no access to the basic necessity for survival, that is water, my lords.
The suit is filed on 17/11/2018. The court had granted an order of status quo. Thereafter, on 29/5/2024, the matter is posted for final arguments. At that stage, the present applications are filed, that is I number 7 and 8.
7.
2 applications are filed, that is 7 and 8. So IA number 8 is filed to install the CCTV cameras. And IA number 8 is filed for installation of CCTV cameras in the premises. And IA number 7 is filed to direct the plaintiff to allow access to the common areas in the suit scheduled property by opening the locks of the common areas, common utilities. That is, 1, roof, public terrace of the building situated in the 4th floor, 2, utility area in the basement, 3, sump tank in the basement, 4, common toilet in the basement. But for that, the objections were filed by the plaintiff stating that now the matter is, the suit itself is going to be disposed of. And at this point of time, only to drag on the proceedings, these kind of applications are filed. The defendant has no right to live in the said property. And the defendant being a trespasser is not entitled for the relief that is sought. According to them, the CCTV cameras are already installed. According to the plaintiff, the CCTV cameras are already installed. The court, by order impugned, had allowed the IA number 7 and 8 filed by the defendant. While allowing the said application, the court observed that the defendant had filed a written statement by way of amendment. She has sought the counterclaim under the provisions of the Protection of Women from Domestic Violence Act, directing the plaintiff from dispersing the defendant number 1 from the B scheduled property. After framing of the issues, the evidence on behalf of the plaintiff as well as defendant number 1 has been concluded. At that stage, the present application is filed. The court observed that there is no dispute about the fact that the son and the daughter-in-law. No, it is son means the
And number 1's
grandson.
minor son, grandson's. He's a school going boy.
1 minute.
That's-
No, defendant number 1 is the
Defendant 1, my lord, kindly.
daughter-in-law.
Daughter-in-law. My
Defendant
lord,
number 2 is her son.
her, my lord, her husband, my lord. First,
Yes.
first defendant's
That,
husband.
That the defendant number 1 is residing along with her minor son. Admittedly, the plaintiff and the 2 sons are not residing in the property. It is also an admitted fact the CCTV cameras are installed by the plaintiff, which is in her control. The said CCTV cameras are not access to the to the said CCTV cameras, the defendant number one had no access. It's also not in dispute that the plaintiff has locked common areas, utility areas, such as terrace of the building, sump in the basement, and common toilets in the basement. The photographs produced by the defendant number one would show that those areas are locked with the plaintiff. The defendant number one, who was residing with her son, she has necessarily access to terrace floor for the purpose of cleaning and monitoring water tank and also a dish antenna. The first defendant needs to access the terrace floor so as to maintain the pipes, etc., utility area and sump area, also necessary as she is using the water from the sump. If there is any leakage, damage or leakage, she needs to access those areas. Therefore, the common areas access sought with defendant number one is reasonable. The court has also observed that the plaintiff had disputed the right of the defendant to reside in the said building. The court felt that whether she has a right to reside in the said building or not shall be decided by the court during the course of trial. Further, when it comes to the CCTV cameras, the court felt that though the CCTV cameras are installed by the plaintiff and which the defendant has no access, she can install the CCTV cameras, and accordingly, by order impugned, had allowed these applications and permitted the defendant number one to access to common areas and directed the plaintiff to open the locks within 3 days from the date of order. And also permitted her to put up CCTV cameras in Schedule A and B properties subject to result of the suit on merits. Next, aggrieved thereby, the plaintiff is before this court. Then counsel for the appellant plaintiff submits that the suit scheduled property is a property purchased by the mother of the plaintiff, and it is not a joint family property, or it cannot be termed as it's not a joint family property, and it is an exclusive property belonging to the plaintiff. He submits that the daughter-in-law cannot have any right in the said property. He submits that the suit is filed in the year 2018, and in 2019 there is an order of status quo. And in the MFA, there is an order by this court to dispose of the suit as expeditiously as possible. He submits that only to drag on the proceedings, the present application is filed. It is stated that the matter is posted for final arguments on 29/5/2024. At that point of time, this application came to be filed. He submits that the son of defendant number one is in fact damaging the property, and she cannot seek for such a relief as granted by the court at this fag end, that too she being a trespasser. He submitted that the application, the appeal is liable to be allowed by setting aside the order passed by the trial court. Next, then counsel appearing for the respondent defendant submits that she is residing in the second floor of the building, and the first floor and the ground floor are vacant. There is nobody is occupying the said building, and the plaintiff is residing with her son. When she is residing in the said building, and whether her entitlement to the property or whether she can retain her possession has to be decided by the trial court after a full-fledged trial. And this till the suit is disposed of, and an order is passed by the court, she is entitled to use the, she is entitled to have access to all the common areas and facilities. It is submitted that she has been put to a lot of inconvenience and hardship by the plaintiff, where the power connection is the power supply is disconnected. And she had failed. She has been facing problems with the water supply. Now the sump is also as a sump is logged by the plaintiff. It is submitted that the in this rainy season, if there is no access to the defendant to reach the terrace, and because of the leakage and other issues, it will be difficult for her to stay in the building. She has been facing all these hardships from a long time. And in fact, she has been getting the water from outside. Now, in view of her, in view of the health, her health conditions, she is not in a position to do the things as she was doing all these years. As such, she has filed an application before the court. And then counsel submits that by allowing these applications, no prejudice is caused to the plaintiff, as the plaintiff is not residing in the said building. It is submitted that the order passed with the trial court is a well-considered one, and that the MFA is liable to be dismissed. Next, for having heard the counsels on either side, for use the material on record. The undisputed facts are that the defendant is staying in the second floor of the building. It is the case of the plaintiff that she is the owner of the property. The property is purchased by her mother, and later she acquired the said property, and she has constructed a house. And the defendant number one, who is none other than her daughter-in-law, had trespassed into the property. She has no right. She has no right to live in the. She has no right to the said property, and she had filed the present suit seeking a prayer of mandatory injunction, directing the daughter-in-law to quit, vacate, and hand over the vacant portion of the Schedule B property to the plaintiff. It is also an admitted fact that the plaintiff is not residing in the said building. She is staying along with the son. According to the daughter-in-law, it's a matrimonial home, and she has every right to reside in the said building. And she had also filed a counterclaim in the suit filed by the plaintiff. Now, the trial court, after a full-fledged trial, has to decide whether the defendant has any right to live in the said property, whether the defendant is a trespasser, and whether the plaintiff is entitled for the relief as sought for in the plaint. There is no as rightly contended by the land counsel for the appellant. This application is filed at the fag end of the trial. It's when the suit is of the year 2018. That application is filed in the year 2024. Just because the application is filed at the fag end of the trial, that itself cannot be a ground for the court to dismiss the application. As long as the defendant is staying in the said premises, she has to have the access to all the common areas and to all the utilities. Now, by granting any of by allowing these applications, no prejudice would be caused to the plaintiff, as the plaintiff is not residing in the building. When once the court comes to the conclusion that the defendant is not entitled, and the other steps would be followed. But as long as she is in occupation of the property exclusively, in the second floor, she needs to have the access to all the common amenities. The, in view of the disputes between between the mother-in-law and the daughter-in-law, she cannot lock it cannot be said that by granting access to the basic, to the common areas, that a prejudice is caused to the plaintiff. This court is not able to appreciate the contentions raised on behalf of the plaintiff, appellant plaintiff, and in the considered opinion of this court, the trial court had rightly rightly allowed the applications, and this court finds no reasons to interfere. Accordingly, appeal is dismissed.
My lords, one submission. I'm not very sure, but while dictating, my lords, probably undisputed facts, it is stated as defendant number one is a trespasser, which is not.
I
the
didn't
case.
say that. Trespasser is not undisputed. Undisputed fact is that, yeah, you are staying there.
Much obliged.
How it can be, how you will say that you are a trespasser? Yes.